मेरे पति मुझे अननेचुरल सेक्स करने के लिए भी जबरदस्ती करता था, मना करने पे
Allegations, even I cannot read it now because there are very serious allegations against the husband and the family members.
allegations are there. Now, does an offense under section 498 of the IPC, or it is a means to harass the entire family out over here who are whatever has she made an allegation what has happened at Mumbai, and that is the allegations are against the husband. बाल्ड वर्जन की उन्होंने बोला कि बाथरूम धुलवाने की बात करी और दूसरी बात नहीं करी। 498
सारा मेरे सर पे डाल दिया करो आप लोग।
कौन सा?
लॉर्डशिप इज वेल अवेयर। मैंने आज तक कभी भी 498 की एफआईआर में ये नहीं देखा कि मैं आत्महत्या करने के लिए मजबूर हूँ।
हाँ। मेरे ससुराल वाले मां से शारीरिक रूप से प्रताड़ित कर रहे हैं। मेरा पति, दोनों नंदे मुझे गंदा बाथरूम, घर का गंदा बाथरूम, टॉयलेट एवं अपने गंदे अंडरग्राउंड साफ करने कहती है, और सभी लोग मेरे साथ मारपीट गाली गलौज करके घर से बाहर निकाल देते थे। मुझे गालियां, सास ससुर सोन से कहकर भोपाल में धमकी देते, तुम्हें जान से माने, तुम्हें लाश गायब करवा देंगे। मेरे ससुर अपने काले कोर्ट वकालत करने वाले बड़े लोगों को जान पहचान बताकर उससे डराते थे एवं गंदी गंदी माँ बहन की गालियां देते थे। मेरा पति मेरे चरित्र पर संदेह करता। मैं कॉलेज में मेरे मायके ये सब फैलाई, किसी लड़के के साथ अफेयर चल रहा है। मेरे ससुराल में आत्महत्या करने को उठाते क्योंकि उनकी पैसे मांग पूरी नहीं कर पाए थे और खाना पीने नहीं देते थे। मेरे पति मुझे अननेचुरल सेक्स करने के लिए भी जबरदस्ती करता था, मना करने पे मुझे नहीं मानता। काफी पीड़ा होती थी, गालियां हैं। फिर 2019 को मेरे ससुराल वाले मुझे घर के बाहर निकाल दिए और मुझे अपने मायके सागर आ गए तथा वहां से आ गए। मेरे फूफा ससुर इंद्रजीत हैं पूना में एवं परिवार के आश्वासन कि अब तुम्हारी किसी प्रकार की परेशानी बाबा बुला लिया। जब मुझे ससुराल वालों ने साजिश का पता चला तो मुझे जान से मारने प्लानिंग कर रहे हैं, तब मैंने मायके की व्यथा बताया। वुमेन सेल बेलापुर महाराष्ट्र में एक आवेदन दिया जिसकी 22 अप्रैल 19 को मेरे ससुराल वाले तरफ मुझ पर एवं परिवार को सागर लाकर लगातार धमकाए जाए ताकि उन विरुद्ध किसी प्रकार का कोई कार्रवाई करने से रखते हैं। मेरे पति राहुल नंद मीनल अहिंसा मुझे लगातार जान से धमकी देगा। मुझे परिवार को मुंबई से परिवार वालों को जान से मारने के लिए माइकल सागर कर दी गई। मेरी मुंबई महाराष्ट्र में काउंसलिंग हो चुका। अब मैं किसी पर काउंसलिंग नहीं चाहती हूँ, अतः माननीय महोदय निवेदन कि निम्न व्यक्ति उचित कार्रवाई करने की स्वयं कार्रवाई की जाए और 11 से 2019 को लॉजिक दी एफआईआर। नाउ व्हाट आई humbly submit, मतलब it's a allegation which is completely bald, which has been leveled against the present applicants, which is there. Now if we see to the document, this document was not made a part and parcel of this women's and Belapur में जो application दी गई।
So many very serious allegations have been made. And this fact is not under dispute, that the applicants were residing at that time in that flat itself, which is clear from the allegations made in the FIR. It has been made. Not all these facts are required to be adjudicated in the trial. And not the matter is at the stage of the framing of charge before the court at Sagar. So, not my respectful submission, not if we read it carefully, not the allegations, even I cannot read it now because there are very serious allegations against the husband and the family members. And for that purpose, Lord, I would like to refer the petition, paragraph 2, 5, 8, and 9, in which they themselves has admitted this fact, Lord, in the petition, that they were residing at Bombay. So the incident had taken place at Bombay. And Lord, the FIR has been lodged on 11/6/2019 at Sagar. Lord, all these facts are covered by the judgment of this court as also by the apex court. Lord, I am placing this is the judgment of this court. In miscellaneous criminal case number 2964 of 2024. Lord, only I would refer page 11.
Yes, sir.
That is clause 14 of that has been reproduced, Lord. From the reading of the complaint, it cannot be held that even if the allegations are taken as proved, no case is made out. There are allegations against respondent number 2 and his parents for harassing the complainant, which forced her to live in the matrimonial home. Even now, she continues to be separated from the matrimonial home as she apprehends lack of security and safety and proper environment in the matrimonial home. The question whether the appellant has in fact been harassed and treated with cruelty is a matter of trial. But at this stage, it cannot be said that no case is made out. Thus, quashing of the proceedings before the trial court is not permissible. The decision referred in the judgment so and so is distinguishable. And thereafter, Lord, in paragraph 11, so many judgments have been referred by your lordship. And at page 13, Lord, it starts with thus: this court can quash the proceedings only if the uncontroverted allegations do not make out an offense. From the plain reading of the FIR, it cannot be said that no causable offence is made out. So far, the territorial and then territorial jurisdiction and the 2019 volume 5 SCC 384 Rupali Devi's case that has also been referred below. And in that, not the mental cruelty, not it continues. Because whatever she has sustained over there, that has continued after shifting to Sagar. So she was very much competent to lodge the FIR, and the Lord that jurisdiction was challenged. And then Lord, on the last date of hearing, that petition has been withdrawn because they raised an objection with regard to maintainability of the petition at Sagar. And that was against that revision was proffered. Then the 482 proceedings were filed. It was withdrawn. So Lord, these points are yet to be adjudicated.
So what is the number of that 482?
Flagged to Lord that first.
Now, the humble submission which I would be making, Malaj, would be whatever my learned friend has just pointed out. It's a bald version which has come over here. At best, it can be said that the allegations are against the husband. Let us read to those allegations which are there on record. I don't say, Lord, I would not be saying that at this particular juncture, Lord should be holding a trial. But let us assume to be there, whatever the allegations are there. Now, does an offense under section 498 of the IPC, or it is a means to harass the entire family out over here who are already implicated? Now, the applicant before Lordships happen to be the unmarried sisters, Nand Hedo. That is applicant number 2 and applicant number 3. Now, she has not made any allegation that she was ever subjected to cruelty at Bhopal. Kindly consider this aspect, Malaj. Whatever has she made an allegation, what has happened at Mumbai, and that is the allegations are against the husband. बाल्ड वर्जन की उन्होंने बोला कि बाथरूम धुलवाने की बात करी और दूसरी बात नहीं करी. Barring that, there is no allegation that these persons have ever demanded dowry or they have harassed the lady. Now, so far as the mother and father are concerned, they were residing at Bhopal. She doesn't say that they had come down over there, they had subjected her to cruelty. Now, Malaj, so far as the other petition, that was the jurisdiction, I'm not touching the jurisdiction aspect. I'm on the merits of the matter. Jurisdiction aspect is not being touched, that the offense could not be got registered. The law is well settled on that point, that wherever the lady goes, she can go down and lodge a report. Earlier, that's why Abraham Ajit and the subsequent judgment Ramesh versus State of Tamil Nadu, they have been held that in spite that a report can be lodged if she goes to her parental home and she lodges a report. On that aspect, that's Rupali Devi's judgment is very much clear. But so far the offense under section 498 is concerned, let us limit ourselves at this particular juncture. We read to the allegation. It is not every type of cruelty. I need not elaborate on that issue, sir. Lordships are well aware as to the scope of section 498A.
सारा मेरे सर पे डाल दिया करो आप लोग.
कौन सा?
Lordship is well aware.
On that issue. And then we go down to the judgment of Geeta Malhotra. And then the judgment of Achin. They make an allegation. It has to be seen from the touchstone. Now, whether these girls who were there residing and doing their own work, now it is one family who's staying over there. The dispute is with the husband and the wife. The wife never wanted to live along with the other persons over there. So the easiest way is make allegations. Some disputes arose, no dispute about it, Manoj, but that is against the husband. Let's assume for the sake of argument, not so far as these persons are concerned, the prosecuting the entire family for no fault of theirs. And Lordships are much aware of that judgment of Kansraj versus State of Punjab. That's 2000 AI 2000 Supreme Court page 2324, where they say a tendency has happened, especially in case of dowry deaths, especially so also for offences in section 4, that the entire family is roped in over there. In those circumstances, Lordship may be kind enough to kindly consider.
But in one or two cases, Supreme Court has also held that the lawyer should use their good office too.
I would say, let us resolve the dispute.
इसमें कुछ ऐसे allegations दिख रहे हैं जो ऐसा लग रहा है कि lawyer के dictation पे.
Very serious allegations.
वो lawyer की dictation में ही है.
I'm not reading that FIR. Not very serious allegations have been.
मैंने आज तक कभी भी 498A की FIR में ये नहीं देखा कि मैं आत्महत्या करने के लिए मजबूर हो रहा हूँ. ये 498A की डेफिनेशन देखने के बाद एलिगेशन लगा है. तो वो सुप्रीम कोर्ट का जो ये डायरेक्शंस होता है नॉट टू एस्केलेट द डिस्प्यूट बट टू यूज द गुड ऑफिस टू रिकंसिलिएट, वो उस पर कोई क्यों नहीं मानता?
हम कर रहे हैं ना सर.
आपकी बात नहीं कह रहा सर.
नहीं, मैं तो आपको बोलता हूँ बैठा ले.
आपकी बात भी नहीं कर रहा सर. शुरुआत जहां से होती है, देखिए एलिगेशन आप लोग नहीं बनाते हैं, एलिगेशन का आंसर वर्मा साहब नहीं दे रहे हैं. factual aspect के ऊपर.
सही
You
बोल
both are arguing on the legal aspect. Whether legally it is permissible for this court to quash or not. पर जहां से शुरू होता है वहां पे सुप्रीम कोर्ट को कोई नहीं मानता. कारण क्या है? परिवार लड़ रहे हैं आपस में. और तो और सर आपने ये भी कहा था सर कॉम्प्रोमाइज यही होगा. आपने ये भी कहा था कॉम्प्रोमाइज तो सर यही होता है.
मैं तो खुद बोलता हूँ. It is ultimately the good offices which work over here and the brainstorm what comes from lordships. Keeping us out of from here with those two persons made to stand over there. The entire matters can be got resolved.
चलिए मैं देख.
We go down to Preeti Gupta's judgment, Manoj. I need not.
क्या पॉल प्रीति गुप्ता कंसराज चंद्रलेखा
वो तो है सर.
बहुत सारे.
That is one aspect, sir. There is another aspect also to the whole issue, which
sir actually
the father-in-law is not, he is coming across. In fact, this is the fact position. Husband wife have no dispute. What father-in-law is coming across. He doesn't want this lady should live with that.
अब वो सर देखिए मैं हमेशा कहता हूँ 482 में neither I can say that the allegations in the FIR are correct nor I can say that the defense which is being put forward is wrong. The only reservation for me is that I have to treat the FIR as a gospel truth. That is the legal fiction, not a finding by the court. That is a limitation on my jurisdiction how to appreciate the things. But once I cannot conduct a mini trial, then I cannot give a finding either in your favor nor in his favor. So I have to consider whether the offences would be made out by plain reading of the allegations or not. That is the only. हो सकता है कि आपका FIR गलत हो, but I am helpless so far as this stage is concerned, not for all times to come. अगर ये इसको आप जनरल स्टेटमेंट देंगे तो वो आपको कहेंगे कि हाई कोर्ट इज हेल्पलेस. नो, बट एट द स्टेज ऑफ 482 अदरवाइज अगर क्रिमिनल अपील आती है then the entire playground is open for us. वो एस्पेक्ट है सर. So let us not say कि भाई who is responsible, who is not responsible. We will go by the facts or allegations mentioned in the FIR, and then we will decide, sir.
in the larger aspect also that may kindly be considered. And one more thing, if ultimately lordships are not agreeing, then I would say,
Sir.
rather than coming on merits, I would say.
Sir.
But so far the unmarried girls, the parents-in-laws, that can.